Hey guys, welcome to my channel. Today's courtroom battle takes an unexpected turn as a mother seeks permission to relocate to another state, while the father argues he hasn't been given enough time to challenge the move. What starts as a dispute over legal notice quickly becomes a debate about parenting plans, custody rights, and the limits of family law. Will the judge delay the relocation, or will one ruling completely change the course of this case? Stay with us to see how every argument unfolds.
You want to have it heard today, or you want to move it to a day in July?
No, no, Your Honor, I want it heard today. My client has got a job, it needs to move, needs to relocate, so we're planning on going forward today. If Your Honor rules that it's not properly before the court, then we'll just have to deal with that. Because again, the issue being is there is no parenting plan. So effectively, Mr. Davis has under the child support worksheet has been afforded 85 days. And so, again, the scenario is it's well within my client's authority to, whether she can move or not is not an issue, but what his visitation is. And if he doesn't mind not seeing the child until we can come back for your September date, we're certainly fine with that.
I was talking about July, but I understand your position. All right. Mr. Hawley, I will hear your argument.
Thank you, Judge. And again, I had filed June 12th this objection to the petitioner's motion to allow the relocation. For the record, it appears that what we have done, the father came to me and was wanting to move forward with a change of circumstances petition. He and I discussed, we put in there that, yes, she was wanting to move to Louisiana, but there's also some mental health issues or some abuse issues or some other things that go along with this petition. It's not just the relocation. The mother, through Ms. Roberts, filed her answer and her counter petition on May 22nd of this year, 2026. I would bring to the court's attention the 30 days to even answer the counter petition at this point has not been exhausted. The father has had no opportunity to conduct any written discovery, take any depositions, otherwise develop the evidentiary record necessary to respond to the mother's relocation claim that she's wanting to take up today. The mother's relocation was filed about June 3rd, 2026. And again, was set for a hearing 13 days later on today's date, June 16th of 2026. It was more or less than 2 weeks after the filing. If we look at the Parental Relocation Act, this codified TCA 36-6-108, it goes on to talk about, in part, Section A says that, and again, in part, the relocating parent shall send a notice to the other parent's last known address by registered or certified mail. One of my objections is she sent a text message. We allege that in our petition. She responded and admitted to that in the counter petition. So I think that's a fact that can be, drawn out. And that's not the proper procedural way by the law to start a Parental Relocation Act. So as far as our position goes today, even short term, that the Parental Relocation Act hasn't even been invoked yet because it's not been started properly. Further, the agreement goes on, further the Parental Relocation Act in Section B provides, again, it's in part that absent agreement by the parties on a new visitation schedule, if it was to be brought about properly, within 30 days of the notice or upon a timely objection in response to the notice, the relocating parent shall file a petition seeking approval of the relocation.
Hawley, is your client here?
He is.
You want to have him come up and have a seat at the table?
And I think that's an important part of the statute because it does say shall. It's not anything that's advisory. It says you have to.
Well, here is my concern. 36-6-108, which is what you cited, states subsection A, after custody or co-parenting has been established by the entry of a permanent parenting plan or final order. In this case, there is no parenting plan or final order of custody that's been entered. All it is a child support an action for child support and a complaint to establish parentage, and child support has been entered by the child support magistrate, but there's been no parenting plan entered. You filed a proposed parenting plan, but there is no parenting plan or final custody order. And the statute that you're referring to, it would require her to comply with that statute by giving notice and so forth, is not brought into effect unless there is a parenting plan or a final custody order that triggers the parental relocation statute.
May I respond?
Yes.
Well, when you say by final custody order, our position would be, when you went to child support court and she was named the primary parent, she received 85 days, pursuant to the calculation of child support, and he's been exercising a reasonable visitation. That's what the evidence will be throughout this time. There's been an order down for that. So to say that there's not been a final order, I think that was pretty well a final order. It never was appealed, and it's still sitting there. And it in part covers a lot of what a parenting plan would cover. It doesn't exactly spell out the days of visitation or talks about decision-making, granted that, but it does declare a primary residential parent. So I would say there has been a final order in this case, albeit through child support. It is sitting there. Again, and I think that the statute is pretty clear that the relocating parent shall file the petition seeking approval of the relocation. And if a petition in opposition to relocation is filed, the court shall determine, and this is C1, the court shall determine whether relocation is in the best interest of the minor child, and that's by way of an evidentiary hearing. And can you have an evidentiary hearing by motion? Yes, you can. Absolutely, you can. But at this late juncture, I can't have an evidentiary hearing today because I've not had an opportunity to gather and corroborate a lot of the evidence that's going to be before the court. I haven't, the time to file an answer to the counter petition isn't even up yet. I haven't had a chance to file interrogatories, depositions, subpoena the people down in Louisiana to talk about the job that there's a lot of suspect information that we've got coming back and forth with that. I haven't had a chance to corroborate any of that. So to try this now with 13 days of notice to say that it's okay to move, I believe she's 8 years old at this point, little girl away from the father, Judge, I don't think this was the intent of the Parental Relocation Act. I think the intent is that if you're going to have these issues, that you have these issues, you file what you need to file, and you come to court with enough time to be prepared to argue the case. And today, we have not had that amount of time, and I think the court can see that clearly just from the amount of time that since it's been filed, since we've had an opportunity to respond and take a look at this motion. Again, I think that continuing or dismissing the motion for the parental relocation at this point is appropriate. That's what I'm asking for, and for us to be able to go through the process and let the process be taken advantage of, so that when we do come to court, we're not stumbling around, we're not bringing up things that may or may not be sufficient or adequate or even plausible evidence at this point. Because right now I haven't had a chance to corroborate a lot of the things that my client has said. And the Court of Appeals has expressly held that, and it's in my response, which I'm relying on, that a parent is entitled to an evidentiary hearing on a proposed relocation. Denial of such a hearing constitutes reversible error. I gave the court a case, Placencia, I believe is the way you pronounce that, versus Placencia, and that's pretty much what it stands for. That the mother in that case had a good job lined up. The father had a good job lined up in that situation, I believe it was, and they were arguing that he should be allowed to go, and they kind of, it really wasn't an evidentiary hearing, I don't think, but it was kind of a hearing in court in a time frame I think was a little more advantageous than this one, actually. And they came back and said that the mother should have been allowed an evidentiary hearing on the father's proposed relocation. And to do otherwise was reversible error. So I understand obviously the situation where mom's got a good job. At this point, we would we wouldn't take that as a grain of salt. We would like to have an opportunity to look at that. My client's got some hearsay-ish type responses and issues and things like that that he wants to track down and try to put this into some sort of evidence so the court will be able to make an informed decision when you do have a proper evidentiary hearing. So again, Judge, I don't think it's fair to the father at this point with 13 days to put him in that kind of position where we got to defend this today without having an opportunity to go through the process. Thank you.
Ms. Roberts?
Yes, Your Honor. Again, the cases cited by Mr. Hawley, I would point out, is prior to the 2024 modification of the rule. The parental relocation statute was modified by the legislature in 2024. So the case law that was submitted by Mr. Hawley predates that. And again, Your Honor has correctly set forth that the parental relocation statute, which is 366108, states that after custody or co-parenting has been established by entry of a permanent parenting plan or final order, if a parent who is spending intervals of time with the child desires to relocate outside the state or more than 50 miles from the other parent within the state, then the relocating parent shall send a notice to the other parent at the other parent's last known address by registered or certified mail, unless excused by the court for exigent circumstances. The notice shall be mailed not later than 60 days prior to the move. The notice shall contain the following: statement of intent to move, the purpose, the location of the proposed, and the reason. That email was sent, or text message was sent to Mr. Davis. But again, the question, number one, starting, has there been number one, there has not been a parenting plan. Contrary to the sworn petition filed by Mr. Hawley that has his signature and his client's signature, wherein they allege that a parenting plan was filed with this court, there is no parenting plan filed with this court. So their pleadings are just patently false and sworn under oath. I would make that note to the court. The only thing that happened is originally this child is a child born out of wedlock. My client sought the services of the Child Support Enforcement Agency and filed a petition seeking child support. Apparently, as you can refer to the court, Mr. Davis questioned paternity at that point in time because a DNA test was performed. And that DNA test came back with 99.99% that Mr. Davis is the father. And at that point in time, a order was filed, a finding and recommendation was filed by the then child support referee, and it was confirmed by the court, wherein Mrs. Now Wingate was designated as the child, Kenley's primary residential parent. Mr. Davis was designated as the alternate residential parent. And the statute said that she was given custody and he was giving reasonable visitation. There is no specific parenting plan. There's no recitation of the parental rights in the state of Tennessee that's contained in that order. Those findings and recommendations that were later found in an order. After that, there was a petition to modify the child support, and there was a finding of a 15% variance in the child support guidelines, and child support was increased, and then the recitation again that now Mrs. Wingate, the mother, was designated as the primary residential parent, Mr. Davis was the alternate residential parent, and that he had just reasonable visitation. The numbers reflected in the child support worksheets that were attached to the findings or recommendation was again 285 and 85 with the father. At no time did the father come in or the mother, either parent come in to seek to clarify or ask for any adoption of a parenting plan. My client, not even being provided the statutory requirements set forth that would have been in a parenting plan, sent a text message. Again, the court, you can talk about strict adherence to statutory obligations, but again, anybody with a modicum of common sense would understand that registered or certified mail is necessary so that the individual had actual notice of the relocation, especially with the process of the United States mail today. And certainly, probably in 2024, the legislature should have maybe modified that by email and some other scenario where you can get you can get notice. But again, registered and certified mail is so to ensure that the court knows that the parent who is non-relocating actually had service. In this case, Your Honor, where it comes back up and says, unless excused by the court for exigent circumstances, the notice will be mailed no later than 60 days. By their pleadings in and of themselves, Mr. Davis admits that he received notice. And that's the threshold of the statute, is that he received notice of the relocation. Prior to Mrs. Wingate being able to even file, he filed. And his petition was not in the form of an objection. He filed stating that there had been a significant material change in circumstances, seeking to have a designation of the primary residential parent change, which Your Honor is aware is a higher threshold than just having a residential schedule done. And there is no residential schedule. So again, the question is, was proper notice of the relocation provided? She did not have adequate time to file a response and to file the statutory procedures because he filed prior to that, prior to giving her no time to even file something. So again, when you go on down the statute, Your Honor, he had actual notice stating, finding that it was not sent by registered or certified mail. Again, seems like an AI type of argument to make. But again, he had actual notice. And again, you have every right to file to ask for the move, and the court can consider it under exigent circumstances. My client, as set forth, has a new job. She's married, she has a new job, and she has parents in the area. And so again, that's the basis of her request to move so that she can start her job. It's during the summer. And again, there is no parenting plan. And so long as my client affords this, there's nothing to contempt her on if he doesn't have visitation. So coming in and saying that you don't want a temporary parenting plan is proverbial cutting your nose off to spite your face under a court order. The court could consider, if my client just went down there and started her job and said, look, you're not going to visit with the child, there's nothing to contempt her on. Of course, it would be one of the factors that the court can consider in a modification, but there's no statute, there's no court order stating when this man gets to see the child or when he doesn't get to see the child. And so long as she somehow complies with the 85 days, then again, there's nothing to say that's not in compliance with the existing final order. In the manifest interest of this minor child, the best interest, she has complied with the notice requirement. He has had actual notice of the relocation. And again, the relocation doesn't have anything to do with his modification. It may, but right now it doesn't. He's just simply filed to modify based on a significant material change in circumstances, one of which, with a liberal reading of his complaint, states that Louisiana is a high crime area, which is laughable considering the circumstances by the United States Department of Justice with the difference in the statutory or the findings of the crime rate in the state of Tennessee and the crime rate of the state of Louisiana. I strongly suggest that they look that up because, again, there's a significant difference. And again, what is laughable in the petition is saying that the schools in Louisiana are deficient, when Tennessee rates next to last in education of its students. And Louisiana isn't behind it. Mississippi is. So again, the only positions that they have filed in their petition to modify is crime rate and education, both of which the state of Louisiana is better than the state of Tennessee. Again, this man had every right to come in and establish a parenting plan. He did not. We're here on a motion to adopt a temporary parenting schedule, which is in his best interest, and we've given notice and we're asking to relocate, which can be by motion.
Well, this court's interpretation of 366108 is that that statute, which requires the notice of parental relocation, envisions that there be a custody order down that sets out the visitation rights or that establishes a parenting plan, because it says after custody or co-parenting has been established by the entry of a permanent parenting plan or final order. We don't have anything other than the child support order in this case, which does make a finding that she's the primary residential parent and he's the alternate residential parent, and we would have reasonable visitation. But there's no limitation on her relocation. There's no indication that as to what his visitation would be, and therefore there's no ability for this court to determine that her moving to Louisiana would deprive him of reasonable visitation. That will be for a hearing, and Mr. Hawley has filed a petition that sets out that there is a material change of circumstances to change the primary residential parent, and that would be something that the court would then have to determine. So I'm of the opinion that that the parental relocation statute requiring the notice was not implicated by the juvenile court or the child support order, and so rule. And as a result of that, the question of whether or not she gave proper notice of relocation is moot, because I find that it was not required. The question of whether the court should or should not allow the relocation and the custody, whether that constitutes a change of circumstances sufficient for a change of custody, will be a factor that the court will consider on your modification request. In the interim period, this court is of the opinion that she is free to move if she wishes to do so, but then you lawyers can either come to an agreement on some sort of a visitation schedule pending the modification hearing, or we can have a hearing on that issue. So,
Your Honor, based on that, we would strike our motion for a temporary parenting.
May I address the court?
you may.
Oh, Judge, would you consider staying that? Before we talk to my client about it, I think we're going to make an application for an interlocutory Rule 10 appeal. This was the order for today. Would the court consider staying your whatever ruling we've got here?
I'm not going to stay it,
but
I don't have a problem with the interlocutory appeal if you wish to seek one, but I am not going to stay my ruling, because I think it clearly is indicated that I'm of the opinion that this statute says when you have an order that establishes a co-parenting or a permanent parenting plan, then that's when it's triggered in. All you have is a custody, or rather a child support order, which by the child support magistrate, without any hearing on the beneficial factors of the statute, all it simply says is that he has reasonable visitation. So if you wish to seek an interlocutory appeal, I'm glad to grant you that request if you want to. But I'm not going to stay the order, the finding that I've made. So.
Okay.
Thank you.
All right. Thank you, Judge.
So the question then becomes, since Ms. Roberts has stricken her motion to adopt a parenting plan, we are still under the reasonable visitation aspect. And Mr. Hawley, if you wish to revisit that issue, you may file your own motion for adoption of a specific visitation plan. I would hope that you all can work something out till we come back.
May I address the court with one other item? Would the court, and I know the next thing I got to talk to him about, and I want to make sure that I'm not wasting his time or money, either one, because she's going to move. She's going to move in the next week or two. I mean, that's just where we're going here. Would the court entertain a temporary restraining order prohibiting her moving if we were to file something like that based on our petition and the fact that we do have a final order out of child support court?
You can file a petition or a motion for a temporary restraining order. From what I have read in the file as your allegations and heard in argument, I do not find that there would be a basis. A restraining order is for an extraordinary remedy that would be for irreversible harm or injury. And, you know, I'm of the opinion what the better practice would be to have some sort of temporary visitation schedule set up to allow this child to visit with both parents while she resides in Louisiana pending your modification.
Yes.
And I would instruct that the lawyer should sit down and try to come up with some sort of a plan, and then that the court will grant you a date in July if you're not able to.
And again, Judge, I would respectfully, we already moved by the time we do that, and to have a child down there and acclimated with school and all those things, it would be very difficult to bring the child back at some other future date. So that's why I'm saying there would be some exigent circumstances here, because to relocate once is one time, to relocate back from Louisiana to Tennessee, that would just put an undue hardship on that child.
I understand. However, this court is of the opinion that I cannot rule on something that's not been filed. And as a result, I've ruled on what was filed, which was the request or your objection to the notice. And I have found that the notice wasn't statutorily required because there was no parenting plan that set forth specific visitation or scheduling. So.
Yes, sir. All right. Thank you, Judge.
All right. Then that will conclude this matter, Mr. Hawley. I've given out a couple of dates in July. If in fact you wish to file something regarding temporary visitation schedule pending the hearing on your modification.
Yes, Your Honor, thank you.
Could the court maybe give us those dates again in July?
Certainly.
July 29th.
July 29th, and I can give you July 30th as well. I just need to know if you're going to utilize the 29th, because I haven't given that out for anything else.
Thank you, Your Honor. And Your Honor, could you...
Please, the court, I would utilize July 29th and at least have that date there so that I can file the motions or whatever we need to do here
Well,
in the
we are
process
holding court on the 29th because I've set that Thomas versus Thomas matter. So,
doing the interlocutory appeal as well. Thank you, Judge.
go ahead.
This case demonstrates that in family court, the outcome often depends as much on legal procedure as it does on the underlying facts. Throughout the hearing, both sides presented passionate arguments about the proposed relocation, the father's rights, and what would ultimately serve the child's best interests. However, the judge focused on a key legal issue. Because no permanent parenting plan or final custody order had ever been entered, the parental relocation statute was not yet triggered. As a result, the court concluded that the mother was not legally required to follow the statute's notice provisions and was free to relocate to Louisiana if she chose. At the same time, the judge acknowledged the father's concerns and encouraged both parents to work together to establish a temporary visitation schedule while the broader custody modification case moves forward. Rather than making a final decision about custody, the court emphasized that those questions would be addressed after a full evidentiary hearing where both parties would have the opportunity to gather evidence, present witnesses, and fully argue their positions. The hearing serves as a reminder that missing legal steps, incomplete court orders, and procedural requirements can dramatically influence the direction of a case. It also highlights the importance of cooperation between parents, especially when a child's stability and relationship with both parents are at stake. In the end, this ruling was not the final chapter in the dispute, but the beginning of a more comprehensive custody battle that will determine the child's future. If you enjoyed this video, don't forget to like, comment, and subscribe. Thanks for watching, and I'll see you in the next video.